Well, let's take you now to The Hague, where the International Court of Justice is on the 5th day of hearings into Israel's occupation of Palestinian territories. The first representative from the British delegation, you see her there, Sally Langrish. She's the legal advisor and Director General of Legal at the Foreign, Commonwealth and Development Office, is beginning her presentation. Let's listen in.
In participating in these proceedings, the United Kingdom underlines its respect and continued support for the court. Our position on the Israeli-Palestinian dispute is long established. We firmly believe that a negotiated two-state solution is the only way to end Israel's occupation, to deliver Palestinian self-determination, and to preserve Israel's identity and security. That belief is founded on the relevant Security Council resolutions and the parties' existing agreements. Recent events only reinforce the importance and urgency of implementing the existing framework. On the 7th of October, Israel suffered the worst terrorist attack in its history. Hamas's terrorist attacks and the ensuing conflict in Gaza have resulted in tragic and large-scale loss of life and injury to civilians. Palestinians now face a desperate humanitarian crisis in Gaza. The United Kingdom wants to see an immediate suspension of the fighting in Gaza and then progress towards a sustainable and permanent ceasefire. It is essential to ensure irreversible momentum towards a two-state solution, guaranteeing security, justice and peace for both Palestinians and Israelis. The United Kingdom has only addressed matters of propriety in its written statement rather than the merits of the request. It takes the same approach in these oral submissions. In doing so, the United Kingdom should not be taken to accept any factual allegation or legal proposition advanced by other participants. Over the course of this week, we have heard certain characterizations of Israel's actions which we don't accept. We have also heard characterizations of our own conduct and the motivation for it, which we emphatically reject. We are confident that the court will find analogies with unrelated cases to be entirely unhelpful. What matters is the case before it today. The United Kingdom confines its submissions to relevant matters of legal principle, firmly founded on the court's own jurisprudence. We submit that the terms of the request do not allow the court to give an opinion in a manner consistent with its judicial functions. The United Kingdom will focus today on 3 key points concerning propriety, which will be developed by Professor Saroushi. They are: first, the impact of the non-circumvention principle in this case. Second, the unsuitability of the fact-finding exercise that the court would have to conduct to answer the request as presently framed. Third, the effect of Security Council resolutions 242 and 338. Each of these points independently provides a cogent reason for declining to answer the request. The court will have observed that our third reason has occupied a particularly prominent place in the participants' oral submissions. Should the court be minded to issue an opinion, then the United Kingdom would respectfully urge it to reformulate the questions to concentrate on the Security Council framework. In this scenario, the court should focus on assisting the General Assembly in supporting urgent progress towards a negotiated solution. I will address this point in concluding the United Kingdom submissions later.